Hello.
Can you hear me? It's
Hello.
okay?
Yes, I hear you. Yes. Oh.
Thank you.
Oh.
Yes, for our colleagues.
I don't know. Do you hear me, Kaja? Do you hear me?
Yes, yes, I can hear you.
See me because something. It's a new picture on my picture. Yes, most nem. Lássa a képernyőjét. Most nem. It's okay. It's
Can
okay.
you see me?
Yeah.
Yes.
Hi. Sorry.
Yeah, Nori. Hello.
Hi.
Hello.
Hello. We are in time.
Okay.
Our colleagues.
And the next seminar is on August. Could you tell me the time of the
Yes,
next
I think
seminar?
10th.
10th? Oh, okay. 10th of August. Yes. Not 17. 10th of August. Okay, I will write it. And how do you develop your article, your study?
Yes, I'm working.
Yes. It's a big work.
Yes.
And it's absolutely it was difficult for me, more difficult than last year.
But when is our deadline, colleagues, for this?
First of August.
For monograph. To the end
no,
of
for the article.
For 1st of August. Yes, the
article
monograph.
To monograph.
Yes.
To whole monograph.
As far as I know, the first article is a chapter in the monograph, and the second study is an article in some law journal, or as
journal.
far as I know. And it is maximum 80,000 characters. Maximum. Maximum.
So it could be less.
Yes, it could be less. I am on about 60,000 to 70,000 because I am on the end of the article, because I want to go to a holiday for to the next week, because I'm really tired.
Hope we all manage.
Yes. Most más a háttered, Nóri. Igen, nem ez szokott lenni.
Yeah, no, because I'm at my parents' house.
Oh, where are you?
Actually, I am on holiday.
Yes. We finished it.
Yes.
I go to the Lake of Balaton. I'm going to the Lake of Balaton this evening, this evening.
That's good.
És hogy állsz, Nóri, az article-lel?
Hát nem jól.
Én ezen a héten.
De akkor ez egy fejezet lesz. Tehát akkor nekem a könyvfejezetet kell.
Igen.
Jó.
Igen. Ezt én sem értettem teljesen kristálytisztán, de ez egy fejezet lesz. Igen, és a következő az pedig egy cikk egy folyóiratban. De még a tavaly is jelent meg, szóval annyira jó updated volt a tavalyim, és most már minden aktualitását elvesztette igazából. The publication, we talk about the publication of the article.
Hello, everyone.
And, hello, Wojtek.
Nice to see you, all of
Nice
you.
to see you. Nice to see you. Are you on a vacation?
Yes, of course. I'm very happy for this reason. The last meeting today and full
Yes.
holiday.
Yes.
For Marta and for Pavel, yes, I think.
Czekamy jeszcze chwilę. Panie profesor, ja tam wyślę jeszcze później poprawiony załącznik z kwietnia, dlatego że w tym tygodniu zwrócono mi uwagę, że tam błędna liczba godzin została wskazanych. Żeby się wszystko zgadzało, to po prostu wyślę do podpisu, a do IWS już przesłałem.
Ten weekend, więc też wszystkie te rzeczy, które tam będę miała na mailu, wydrukuję, podpiszę i wyślę im.
Super.
No, już chyba nie zdążyłam twojego wysłać, bo późno wieczorem
Nie ma problemu.
przyszedł ten mail, ale zrobię to w ten weekend.
Nie ma problemu. Formalities.
So maybe we can wait. Hello, Marta.
Hello.
Hello. Yeah.
Hej.
You are in your office, I see.
I'm
Not-
always in the
Not in a vacation. If we finish, I will go to the Balaton.
Very good.
Waiting for Paweł Zając.
Hogy állsz, Márti, a cikkeddel?
We are talking about the chapter.
Yes. But it's very top secret.
Fele van meg.
Mhm. Én majdnem befejeztem. Már csak a de lege ferenda javaslatok vannak.
You are a star.
No,
Yes, you are.
szerűen no. Sokkal nehezebb volt, mondtam a többieknek, mint a tavalyi nekem ez most. Nem jó témát választottam.
Ez egy összetett téma nagyon, amit választottam.
Hát nem is tudom, mire jutottam benne, majd elküldöm neked. Perhaps
I don't know,
he
maybe we
forgot
can-
it. Perhaps Pavel
can
forgot.
start because I don't have any info from Dr. Zając. With connection. Oh, okay. Mhm. Past 6 p.m. So maybe we can start. Yes. Okay. So good afternoon, dear professors and dear colleagues. I hope you rest a bit after academic year, and time flies quickly. So I welcome you warmly to our third seminar entitled this time EU and government program strategies in both countries, as well as case law regarding the rights of children with disabilities. And just a reminder, seminars are carried out as a part of the research project Legal Protection of Children with Disabilities within the Polish-Hungarian Research Platform 2023, organized by Justice Institute. And my name is Katarzyna Ruszewska. I'm an associate professor of law at the Cardinal Stefan Wyszyński University in Warsaw. Presentation will be given as always by professors from Hungary and Poland, and I always present the titles of our speeches, so I do it this time as well. And Nora Jakab, EU and government program strategies in Hungary, as well as case law regarding the rights of children with disabilities. Zuza Wopera, the procedural status of children with disabilities in cross-border family law cases in EU law. Marta Benius, interpretation of the principles by judicial bodies, both national and international, with a special regard to live and survive. Wojciech Lis, forms of help for a family with a disabled child. Paweł Zając, we are waiting still. Strategy for ensuring the safety of children with disabilities in cyberspace, and me, EU and government's programs strategies in Poland, as well as case law regarding new technologies in the implementation of the rights of children with disabilities. And from the next time, I think we can reverse the order, but today I suggest starting the same as in previous seminars. So Professor Nora Jakab, please, the floor is yours.
Thank you, dear colleagues. And I cannot see anybody from outside. Am I right? Because
yes, probably yes.
yes, I think there is nobody outside because we're supposed to have this as an open seminar. Nevertheless, you all know, as Professor Rozeska also introduced the topic, which is the right to social security regarding the disabled children. However, it is such a topic, as I described you earlier, that we cannot really separate it from the right to social security on behalf of the parent. Because it's very important if we have a family safe and sound and in a financial stability, then of course it will ensure that family and that parent the safety of the children, whether they be disabled or not disabled. And in the previous occasions, I have tried to outline the international and the Hungarian framework of social rights and the right to social security. At international level, it was very important to look at the right to benefit from social security as the Convention on the Children's Rights prescribes it. However, last time I have dealt with the Hungarian situation, and as we have a comparison to the Polish system as well, now I have tried to go deeper into the Hungarian situation of the child protection system regarding the situation of disabled children. In the coming chapter that we have to write into the book, I am going to provide you with more details. Now I just would like to give you some information what I would like to talk about in this chapter. Now I don't have, and actually I'm not having any presentations, but just very shortly, I would like to tell you that regarding the child protection system, the legislative processes in 2021 and so on were heavily influenced by the coronavirus epidemic. Maybe it is the situation also in your country, in Poland. And as a result of the state of emergency as a special legal order, the regulation by decrees were maintained at that time. And now after the corona crisis, it is also usual that the government uses decrees to outline the details, for example, in the Education Act or in the Child Protection Act, some provisions. However, regarding the administration from 2021, the Unified Regional Child Protection Service in the capital and in our counties have been established. And regarding the administration issues, I think that it can be a good sign that now we have got this Unified Protection Service. And we have got the establishment of the National Child Protection Specialist Service, where the separation of the administration from residential care has been created. And in terms of legislation, in the area of child protection, we have got a phenomenon in Hungary, and it is not an easy situation to deal with, because it's okay, and we accept that the legal environment for services that we have, and I think my Hungarian colleagues can just justify that. The legal environment for services has been for decades very stable. However, we have got a spontaneous legislation with short deadlines, which often leads to not satisfying content of the legislation. And this kind of legislation are often introduced into the social care system. We sometimes call that kind of legislation in the child protection system as salad law. And actually, it is now a permanent problem. This is a changing environment, and it is difficult sometimes for professionals to follow. And it makes many of us very uncertain and makes us too difficult to work together with other professions to make an improvement. There is also an evidence in this field that the media often identify areas, for example, ad hoc codification measures. And actually, many times, very important issues are neglected. When we look at the services which are provided within the family protection and child protection system, but now I would like to distinguish a little bit, because when we talk about the Child Protection Act, then it's important that there are services that belongs really to Professor Benyus' competency. I would like to focus in this chapter on the services regarding the social security system, and regarding some family services which are not included in the social security system. And I would like to focus in the chapter in services for the parents to help them to raise their children or raise their child. And it doesn't matter whether these children are disabled or non-disabled. So the services which are going to be included are the following. We have got in the social security system under the health security two very important services. The first one is the infant care allowance for the first 6 months of the child, and then till the 2-year-old of the child, we have got childcare allowance, and these two are very important bases for the children in the social security system, whether disabled or not. Then we have got services which I think form a considerable part in the state budget, but are not based on the social security system, and these are care allowance, family allowance, and child rising allowance. And we can see in the state budget in 2021-22 and also this year that the amount of the services which are based on the insurance and which are included in the health insurance system, which means in the social security system, they are going to be higher, and they have been raised in amount in the last 2-3 years. But that kind of allowances, which are not included in the social security system, they are very small amount of money, and it has not been changed for decades. And when I was talking about, as we all know, the nature of the social rights, that they are very expensive social rights, and actually it is really it really depends on the capability of the state, what kind of financial burden it can bear, really shows now that care allowance, family allowance, and child raising allowances with this very small amount of money does not really make a life that is a sort of help to live in dignity. Because if there is no insurance on behalf of the parents, then they get such a small amount of money that they cannot make a living on it. However, this is the nature of the social rights. There is another issue I was looking at, and I will look at in the chapter, and it belongs to the strategy on the rights of people with disabilities, because in March 2021, the European Commission adopted a strategy on the rights of people with disabilities for the period till 2030. And among the priorities of the strategy, the situation of children is highlighted in the context of decent quality of life, independent living, and access to inclusive education, as Professor Rozewska has talked quite a lot about this. And in this context, the Commission has published in 2021 a toolkit for inclusion in early childhood education and care, and will support the development of teacher training to combat the exclusion of pupils with special education needs. And of course, the member states has quite lots to do regarding people with special needs, or children, pupils with special education needs. Therefore, the fourth direction that I went into, so the first was the legislation, the second one was the administration, the third one has been the services in the social security system and in the family support system. But the fourth direction is what kind of actions we have made regarding to this strategy. Because when we talk about the security of disabled children, in the social security of disabled children, then the proper education cannot be disregarded. And I think that it's important because they have got special needs. And with the special needs, they are entitled for special services. On the agenda in Hungary, in recent years, there has been the large-scale replacement of institutions providing care for people with disabilities. However, that kind of strategies, unfortunately, has not yet had a significant impact. And I don't know what the situation in Poland is like, but we have got great strategies, but unfortunately we fail with the implementation. And when we look at the placement of children, then we can see that there is a slow decline in recent years in the residential institutions. So actually in the number of people, in the number of children aged between 0 and 27 living in residential institution for people with disabilities. So the problem is that we have got really a sort of exclusion direction. And there is also no change in the placement of children with special needs in specialized care, unfortunately. And we can see that there is a particular shortage of foster parents as well, capable of caring for children with special needs. So these children are almost all in institutional care, which is really an important issue in our country. And we can also see that to date, unfortunately, the statistics show that the children with special needs are particularly disadvantaged in Hungary. For example, children under age of 20 are much more in care institutions with compared to those children who are under the age of 12 and who are not children with special needs. And as my time flies, I just would like to summarize another issue, that we have got the Ombudsman inquiry. Many times it shows the situation of disabled people and disabled children. And this Ombudsman inquiry, following an individual complaint, has also highlighted systematic problems in Hungary in the education and the institutionalization of children with disabilities. And with regard to education, the Ombudsman's inquiry found that children with special education needs were not always provided with access to education adapted to their condition. And unfortunately, those who need long hospital stays have very little access to the education they need. And that's the point where the social services also have connection to the education. They cannot be really separated from each other. Of course, I will also look at the Public Education Act, and I will also have some other issues about the public education, to the decrease of the Public Education Act regarding the educational issues of the Hungarian disabled children. So I think my time is over. I just would have loved to outline what I will write about. Thank you very much.
Thank you very much, Professor Jakab. This was completely new information for me about solutions in practice, yes, in your country. Now I would like to ask Dr. Zuzana Opera to give her presentation. Please, Doctor.
Thank you so much. Good afternoon, all of you. I am Zsuzsa Opera from the University of Miskolc. I am professor of law, and I am the head of department of the civil procedure law. It's a great honor for me to share with you in the next few minutes the results of my ongoing research. So this is it will be my conclusions of the one part of my project. The title of my presentation is Some Issues of Procedural Status of Children with Disabilities in Cross-Border Family Matters. The EU legislation is also determined by definition within the international legal framework of the UN Convention on the Rights of the Child, the CRC, and in the Convention on the Rights of Persons with Disabilities, the CRPD, and the Convention of Council of Europe, as I analyzed in detail in my previous presentation. As I mentioned in my first presentation, the strengthening of the child rights approach can be observed in the secondary EU law sources. For example, in the Council Regulation EU 2019-1111, this is the Brussels 2B regulation and jurisdiction, recognition and enforcement of decision in matrimonial matters and matters of parental responsibility and on international child abduction. It is entered into force at 1st of August 2022, so last August. This approach can be seen both in the field of central and clear regulation of the child rights to be heard. According to the 21 of Brussels 2B regulation, the court of the member state shall, in accordance with national law and procedure, provide the child who is capable of forming his or her own views with a genuine and effective opportunity to express his or her views, either directly or through a representative or an appropriate body. The court shall give due weight to the views of the child in accordance with his or her age and maturity. According to the Article 26 of the regulation, the Article 21 of the regulation shall also apply in return proceeding under the Hague Convention. It can be seen that both the Brussels 2B regulation and the CRC, it was what I analyzed about 2 times before, ensure the right of the children who are capable of forming their views to express their opinion in the procedure affecting them. In my today's presentation, at first, I will focus on the criteria of child's ability of forming views based on the relevant international legal documents. The interpretation of child's ability of forming views is of a fundamental importance from the point of view of the exercise of the right to participate of children with disabilities. Question to be answered is the next. Can the child's ability of forming views be linked to a certain intellectual level or a communication skills? It is worth making a parallel between the age limit of the capability to form a view and the intellectually disabled child, since the question of age also arises because at a given age, it can be assumed that the child has the necessary maturity. First, I would like to focus on the recommendations of the guideline of the Council of Europe on the child-friendly justice, adopted in 2010, as you know exactly, and in the light of the jurisprudence of the European Court of Human Rights. The participation is the first principle in point among the fundamental principles of the guidelines. According to this provision, the right of all children to be informed about their rights, to be given appropriate ways to access justice, and to be consulted and heard in proceeding involving or affecting them should be respected. This includes giving due weight to the children's view, bearing in mind their maturity and any communication difficulties they may have in order to make this participation meaningful. I would like to draw attention to this wording, according to which the right to participate must be ensured despite any communication difficulties. The fourth fundamental principle of the guideline is the point D, is about the protection from discrimination. According to this provision, the right of children shall be secured without discrimination on any grounds. Specific protection and assistance may need to be granted to more vulnerable children, such as children with disabilities. The guideline stated that in all proceedings, children should be treated with respect to their age, their special needs, their maturity, and level of understanding, and bearing in mind any communication difficulties they may have. The explanatory memorandum of the guidelines makes it clear that the reference made to the term capable of forming his or her own views shouldn't be seen as a limitation, but rather a duty on the authorities to fully assess the child capacities as far as possible, instead of assuming too easily that the child is unable to form an opinion. State should presume that the child has, in fact, this capacity. It is not up to the child to prove this. The leading case of the European Court of Human Rights is the Sahin. Sorry, I don't know. The pronunciation is good. The Sahin it's a Turkish man, versus Germany, in which the court made a judgment in 2003. A relevant factual element in the case that the applicant initiated a proceeding in Germany in order to grant the right of access to his daughter, born out of wedlock. During the first instance proceeding, the almost 4 years old child wasn't heard because the expert opinion was taken as to the basis for the conflictual relationship between the parents. The court of the second instance that didn't hear the child, who was already 5 years old at that time. In this regard, the European Court of Human Rights made the following statement. It is essential that the competent court give careful consideration to what is the best interest of the child after having had direct contact with the child. The court found that the substantive violation was the failure to hear the child's own view and indicated that the national court had to take considerable steps to ensure direct contact with the child, and that by this means only can the best interest of the child be ascertained. The court found that Article 8 of the European Convention on Human Rights requires that the domestic authorities should strike a fair balance between the interest of the child and those of the parents, and then in the balancing process, particular importance should be attached to the best interest of the child, which, depending on their nature and seriousness, may override those of the parents. Nevertheless, the court found, as regard the issue of hearing the child in court, the court observes that as a general rule, it is for the national court to assess the evidence before them, including the means used to ascertain the relevant facts. It would be going too far to say that domestic courts are always required to hear a child in court on the issue of access to a parent not having custody, but this issue depends on the specific circumstances of each case, having due regard to the age and maturity of the child concerned. I would like to speak briefly about the ongoing Council of Europe's draft recommendation, which combines the international and EU requirements related to the hearing of the child. This is the draft recommendation on the protection of the rights and the best interest of the child in parental separation and in care proceeding. Since 2020, the Committee on Experts set up by the Committee of Ministers of the Council of Europe has been working on the recommendation that defines of the rights and the best interest of the child in parental separation and in care proceeding. The overarching principles include that right to be heard, otherwise known as the right to participate. According to the draft recommendation, the child should be provided with a genuine and effective opportunity to express his or her views, either directly or otherwise, and be supported in doing so through a range of child-friendly mechanism or procedure. The child's level of understanding and ability to communicate, as well as the circumstances of the case, should be taken into account. It should be presumed, it's a very important statement, but founding, it should be presumed that the child is capable of forming his or her views. Where a child needs assistance or is unable to express his or her view due to age or capability, the child's perspective on relevant matters should, where relevant, be ascertained by a specially appointed and skilled representative or professional. Finally, allow me to summarize the results, the conclusion of my research at the field of the international and EU law research, because next time I would like to speak about the Hungarian regulation. And this is the topic of my, of course, my first article, my chapter. From the international and EU legal provisions, the general comments and explanation, and from the findings of the international judicial practice, the following summary statement can be made regarding the disabled child's right to participate. First, the procedural law status of disabled children in cross-border civil cases is determined by the provisions of the CRC, the CRPD, and the Charter of the Fundamental Rights of the European Union, analyzed in detail earlier. It follows from all three legal documents that the right to be heard in the procedure must be ensured regardless of disability. All children are capable of expressing a view. The third is the practice of the European Court of Human Rights and the Court of Justice of the European Union have also confirmed that the right to be heard must also be ensured for disabled children, because the ability to form views cannot be linked to an age limit or an intellectual capacity. It is worth noting that the CRPD and the Charter of Fundamental Rights of the European Union do not even link the right to be heard to capability of forming views. The fourth is, it should be presumed that the child is capable of forming his or her views. The fifth, children with disabilities must be ensuring genuine and effective opportunity to express his or her views. The next, states must provide appropriate assistance, professional support to children with disabilities to realize the right to be heard. The disabled children must also be informed that they have the right to express their views in the proceeding affecting them. The next is, the right to participate belongs to the disabled child both as an individual and as a group of disabled children. Both must be provided with the opportunity to participate in the procedure affecting them. Expressing view is not an obligation, just an opportunity for the disabled child. The disabled child has the right not to exercise this right. And the last is, the views of the disabled child must be given due weight in accordance with his maturity. So despite this, the above-mentioned and cited clear and progressive international and EU legal regulation, the EU strategy on the right of the child, adopted in 2021, doesn't give a favorable account of the participation of children with disabilities in justice system. It is found that children face difficulties to access justice and to obtain effective remedies for violation of their rights, including at European and international level. Vulnerable children are often exposed to multiple and intersecting forms of discrimination. Children with disabilities experience difficulties due to reduced accessibility of justice system and judicial proceedings and lack accessible information on rights and remedies. Data collection of children involved in judicial proceedings, including in the context of specialized courts, should be improved. I hope that our research will help to improve this situation. Thank you for your kind attention.
Thank you very much, especially for the examples of court cases. And now, please, Dr. Marta Benius, you may start.
Yes, thank you very much. Good evening, everyone. My name is Marta Benius, and I work at the Ferenc Máter Institute of Comparative Law. And my topic today would be the interpretation of the principles of the Convention on the Rights of the Child by judicial bodies, including both national and international level. In my first presentation, I introduced the layer of international human rights law. I talked about the 4+1 principles of the UN Convention on the Rights of the Child, so non-discrimination, best interest of the child, the viewpoint of the child, the right to live, survive, and develop, and as a +1, the right to live in a loving and caring family environment. These principles give the prisma of the child rights perspective, the so-called children's rights glasses. In my next presentation, I examined the implementation of these principles into Hungarian law, where I concluded that we cannot talk about a comprehensive child rights approach in connection with children with disabilities. As to the interpretative work of judicial bodies, I aim to talk about both international and national forums. Firstly, let's take a closer look which are the international judicial bodies that fall within the scope of my research. As the angle of my study is the UNCRC and its principles, which was adopted under the umbrella of the United Nations, I stay on the field of universal system of human rights law, So I will not cover the regional systems such as the system of Council of Europe, the Inter-American or African human rights system. Therefore, the quasi-judicial bodies that can be mentioned here and having more or less an interpretative power is the Committee on the Rights of the Child and the Committee on the Rights of Persons with Disabilities, and also other human rights committees where an issue of infringement arises. These committees are bodies of experts that monitor and promote the implementation of the CRC and the CRPD. The primary mandate of the committees is to ensure the effective implementation of the Convention by states. They monitor the progress made by countries in fulfilling their obligations under the Convention and provide guidance and recommendations to improve the protection and promotion of children's and disability rights. Under the optional protocols on communication procedure, the committee may act as a judicial body, and in case of child rights or disability rights infringement, if domestic remedies are exhausted, has the power to take action if a communication procedure is initiated and if a state is part of the optional protocol. So the committee coordinates state reporting, issue concluding observation, issue general comments, decisions that are binding on those states who have ratified the optional protocol. I have mentioned previously, but I have to repeat it again, that Poland has not ratified the optional protocol on the communication procedures, none to the CRC, none to the CRPD, and Hungary just ratified the one to the CRPD. Before having a look into individual cases brought before the committee, I would like to briefly mention the joint statement, which legally is not a binding document, but an awareness raising indeed that was issued by the CRC and the CRPD committee in 2022, March 18, and reaffirmed that all the principles and rights enshrined in the CRC and in the CRPD are interrelated with respect to children with disabilities and are underpinned by the human rights model of disability. The statement made comment on all of the principles. On non-discrimination, it noted that discrimination is often hidden because children, particularly children with disabilities, are not given the appropriate fora to share their experience in society, to participate and to be heard in all decision-making that affects them. The committee recalled the common obligation of state parties to the CRC and or the CRPD to make measures to eliminate all forms of discrimination, including multiple and intersectional discrimination. As to the best interest of the child, the committee urged the state parties to apply the concept of the best interest of the child contained in Article 3 of the CRC and 7 of the CRPD to children with disabilities with a careful consideration of their evolving capacities, their circumstances, and in a manner that ensures children with disabilities are informed, consulted, and have a say in every decision-making process related in their situation. As to the respect for the views of the child, the standard of Article 12 of the CRC and 7.3 of the CRPD on the right to be heard requires states to parties to examine their laws and policies to ensure that the autonomy, will, and preference of children with disabilities are well understood and respected on the equal basis with other children. The committees underlined that discrimination against children with disabilities make them disproportionately vulnerable to violence, including corporal punishment, neglect, and abuse in all settings such as the family home, mental health, educational, or child care institutions. Therefore, the committee called on state parties to urgently adopt comprehensive strategies to eliminate violence against children. As part of the right to development, the right to inclusive education is also emphasized with a manner that high-quality inclusive education requires the education of all children on equal terms in the same general educational system, adapting the educational system to the diverse educational requirements, abilities, potentials, and preferences of each child. The joint statement also recalls the right to family and says that state parties shall respect the right to family life for children with disabilities on an equal basis with other children. The committee agreed that all children, for the full and harmonious development of their personalities, should grow in a family, in an atmosphere of happiness, love, and understanding. The institutionalization of children with disabilities are not acceptable and call on state parties to end institutionalization on the basis of disability and to promote the development of support for children in a family in the community. In accordance with both conventions, state parties have the obligation to adopt clear and targeted strategies for desinstitutionalization with specific time frames and adequate budgets in order to eliminate all forms of discrimination and segregation of children with disabilities. Specific attention should be paid to children with intellectual and psychosocial disabilities and children requiring high levels of support who are usually at a higher risk of institutionalization. The committees call on state parties to provide inclusive and supportive services for children with disabilities and their families. After these general remarks, I would like to make a few comments on some particular cases that were brought in front of the committees and were decided it in merits. I ran a search on children with disabilities and found few cases where the rights of children with disabilities were interpreted. I here at this presentation will mention only some work of the CRC committee, but in my paper I intend to mention also the CRPD committee. In a case against Belgium, the CRC committee underlined that the fact that a child is very young and in a vulnerable situation, meaning that has a disability or belongs to a minority group or is a migrant, does not deprive him or her the right to express his or her views, nor reduces the weight given to the child's view in determining his or her best interest. In a case against Denmark, and also in a case against Switzerland, when a child was to be returned to a country where an adequate treatment or help with the disability condition was not guaranteed. From Denmark, the child was to be deported to China, and from Switzerland, the child was to be deported to Russia. The CRC committee recalled its general comment number 6, in which it stated that the states are not to return a child to a country where there are substantial grounds for believing that there is a real risk of irreparable harm to the child, such as, but by no means limited to those contemplated under Article 6 and 37 of the Convention, and that such non-refoulement obligations apply irrespective of whether serious violations of those rights guaranteed under the Convention originate from non-state actors, or whether such violations are directly intended or are the indirect consequence of action or inaction. The assessment of the risk of such serious violations should be conducted in an age and gender-sensitive manner. Such assessments should be carried out following the principle of precaution and where reasonable doubt exists that the receiving state cannot protect the child against such risk, so the disability will not be treated or taken care of profoundly, state parties should refrain from deporting the child. After shortly covering the international layer, I would like to turn to the interpretative work of the Hungarian courts. Firstly and foremostly, the Hungarian Constitutional Court, and unfortunately there is no extensive framework that would lead us specifically in connection with the rights of children with disabilities. Nevertheless, I would like to pull out one case where the right to development of children with special educational needs were strengthened, aligned with the rights of children to an individualized development. The case is also about equal opportunities, so non-discrimination and the best interest of the child. The Constitutional Court, acting ex officio, held that the lawmaker had infringed the fundamental law by failing to enact, together with the introduction of the provision of the National Public Education Act, introduced on 1st January 2020. The introduction was that the child shall become obliged to attend school in the year when until 31st of August they reach the age of 6. It guarantees the rules that ensure, at least at the same level as the legislation previously enforced, that despite the reduction of the maximum period of kindergarten attendance by 1 school year, children with special educational needs may receive the necessary development to fulfill their compulsory schooling in integrated education together with children taught in normal educational schedule. Under the previous legislation, the child could stay in kindergarten education for 1 year longer than the mandatory period, which could be extended by 1 additional year on the basis of a recommendation from the expert committee. In this constitutional complaint, the petitioner explained that the current legislation violates the interests and rights of children with disabilities, discriminates against children with medically certified illnesses, violates their fundamental right to proper physical, mental, and moral development, and violates the right of the parents to choose the education of their children. In its decision, the Constitutional Court explained that an amendment to the contested provision of the law that deprives children with special educational needs of the possibility to attend kindergarten for an additional year in order to start their primary school education in an integrated form in line with the fundamental law only if, at the same time as abolishing the advantage, the lawmaker creates additional guarantees for the kindergarten education of children with special educational needs that are capable of ensuring at least the same extent as the possibility of having 1 more year of kindergarten education, that children with special educational needs may start their primary education in an integrated manner. However, the lawmaker failed to provide for such an additional preferential rule. The Constitutional Court stressed that the legislative context, although it is not in itself against the fundamental law, is indeed not in conformity with the fundamental law. Nevertheless, the lack of conformity is not caused by the current content of the contested provision, but by deficiencies of it and of other rules of the legal system. Thus, the Constitutional Court, acting ex officio, found that the lawmaker had caused an infringement of the fundamental law by failing to create, at the same time as amending the law, the guarantee rules which would ensure that children with special educational needs could receive the necessary development during kindergarten education, at least at the same level as under the previously applicable legislation. The Constitutional Court explained that the lawmaker has a number of means at its disposal to create a system of guarantees equivalent to the previous legislation, which can be done either by restoring the maximum duration of kindergarten education for children with special educational needs from whom the possibility of integrated primary education is genuinely available, by improving the intensity and effectiveness of development in the preceding kindergarten education where possible, or for children with special educational needs who were born prematurely, even by using the calculation method for the period of pregnancy instead of actual date of birth. The Constitutional Court called on the Parliament to comply with its legislative duty. The lawmaker basically after complied with it and restored the parents' discretional right to take their children to school. In other decisions in connection with the rights to live, survive, and development, the Constitutional Court underlines the nature of children's rights, which is a triangle, where the right holder is the child and the obligation to guarantee right is on the parents of the child. The third party in this triangle is the state, who stands behind the parent in case of vulnerability, such as disability. The responsibility of state, in my opinion, state raises even more. As a conclusion, I would like to make a remark that after reviewing the practice of committees, judicial bodies, the invisibility of children with disabilities is even more striking. The triangle nature of children's rights should be more emphasized and targeted by comprehensive strategies of national level to reduce this invisibility. Thank you very much for your kind attention.
Thank you, Dr. Bendis, very much, especially for this bright view of international and national rights of the child with disabilities. And now, because Dr. Zając is missing, next to the last, I would like to invite Professor Wojciech Lis with his presentation, please.
Hello, everyone, one more. My name is Wojciech Lis. I am a professor of law at the John Paul II Catholic University of Lublin. This time I would like to share some comments on the subject forms of help for a family with a disabled child. I will not focus here solely on the legal aspects, but I will try to present the problem in a broader sense. The birth of a child is a huge and important event for parents that changes priorities and reorganizes family life. An even greater challenge is the birth of a sick or disabled child, which requires full dedication and special care. Very often, the parents of such a child themselves need help and support in every aspect of their life. Assistance offered to families with a disabled child normally is associated with in-kind support, which may take the form of material or financial assistance in the form of various reliefs, subsidies, or allowances. Undoubtedly, it is an important form of help for a family that faces the challenge of meeting the specific life and development needs of a child with a disability. Typical forms of financial support include care allowance, special care allowance, nursing benefit for resignation from employment or other gainful work, supplement to the family benefit for education and rehabilitation of the child, family allowance or an addition to the family allowance for education and rehabilitation of a disabled child, relief in the annual tax return, allowing expenses for the needs of a disabled child to be deducted from income, relief in rail and bus transport, discount on public transport, discount on the purchase of entrance tickets to museums and other similar cultural institutions. Other targeted funding options are also available, such as co-financing of rehabilitation stay, provision of rehabilitation and orthopedic equipment and aids, primarily diapers, hearing aids, glasses, orthopedic footwear, wheelchairs, and anti-bedsore mattresses. Particularly noteworthy is the co-financing of the removal of architectural barriers, including the purchase of a mobile lift or installation of a ceiling lift, which facilitate the daily movement of a child with a disability. To this should be added the scope of facilitations in the labor law, namely an employee who is the parent of a disabled child may apply for flexible forms of employment if it does not violate organization of work or the type of work performed by the employee. The amounts of this support, especially allowances, do not compensate for most of the costs related to meeting the needs and functioning of a disabled child. Equally important, sometimes even more important, is intangible support, emotional, spiritual, informational, instrumental, and social. In order for the support provided to the parents of a disabled child to be effective, it must be multifaceted and multidimensional. Emotional support is to build a sense of security, mutual trust, acceptance, and care through verbal and non-verbal messages. It boils down to conveying positive emotions that reduce anxiety and suffering, strengthening parents in their daily struggle with difficulties caused by the child's disability. Emotional support refers to important motivational forces, allows parents to remove fear and add faith to continue struggling with difficulties. It is closely related to spiritual support, which is designed to help understand one's position in the existential context, providing support by referring to specific values and beliefs of a person in need of support, showing the role of suffering in human life, and then giving sense to these experiences. Information support often takes the form of instruction. The person in need receives directions, instructions on where to go and what to do to get help, how to cope with problems. Parents of a disabled child must be aware of the difficulties they will have to face, what possibilities and limitations their child has, how to organize family life so that the needs of each of its members are met. In this context, it is particularly important to emphasize the importance of information, primarily on specialist services, forms of housing for people with disabilities in the future, the possibility of obtaining assistance in the form of benefits and institutions providing this type of support. Unfortunately, parents of children with disabilities often do not know what kind of support they can apply for. Instrumental support concerns the provision of services and treatments for people in need that will facilitate or improve a difficult life situation, are related to providing parents of a disabled child with skills necessary due to his or her disability, equipping them with specific reaction scripts to facilitate everyday functioning. The essence of social support is mutual interpersonal relations, building a sense of solidarity, exchange of experiences, and common observations. This is related to the desire to accept, notice, and appreciate the potential of given person with the help of verbal and non-verbal messages. Social support can create more optimal conditions for the further development of a child with a disability, and parents will not feel lonely and helpless due to the situation in which they find themselves. Helpful are support groups in which families in a similar life situation meet, which can help them counteract the social isolation. Parents also seek support in self-help groups where they exchange their experiences and ways of dealing with various difficulties and limitations. For parents of disabled children, it is very important to understand their life situation, break away from everyday struggles with the child disability, but also to relieve, even if only temporarily, from taking care of the child. Such activities will protect oneself from physical and emotional exhaustion, provide the opportunity to rest and detach from everyday duties. The ability to switch attention to other issues, not related only to the child illness, change of environment, contact with other people has a positive effect on the parents' well-being. Taking care of their mental condition, they directly care for the emotional comfort of their children. Each kind of support is an essential element of helping a family with a disabled child. Such support should be understood in many aspects and should be provided in the most individualized way because each disabled child is different and the situation of his or her family is exceptional and unrepeatable. Therefore, the support also should be adapted to its current and real needs. It should be emphasized that the greatest support is offered by state, government, and local government institutions. The State Fund for Rehabilitation of the Disabled, Powiat Family Assistance Centers, municipal family assistance centers, and communal social assistance centers. In the case of supporting parents of a disabled child, both specialists and people who are not professionally involved in helping are important. Each of them provides help in different aspects of life, depending on the needs. A family with a child with a disability should be systematically recognized, and the support provided to them should be of an interdisciplinary nature. It is necessary to increase the cooperation and engagement of all institutions dealing with the child and the family, helping the whole family, not just a child with a disability, because a child's disability determines the life of all family members, parents, siblings, but also distant relatives. In conclusion, I would like to emphasize that material support, although important, will not replace direct contact, especially with the closest family members. The birth of a sick child is a difficult experience for the whole family. That is why it is so important to help his or her parents, so that they can take special care of the child and be able to demand that their rights be respected, especially when children are at risk of being rejected by others. Most of all, the family should protect them so that they feel needed and loved like other children. The family should be responsible for the fate of the disabled children, strive for their physical and spiritual adoption, and include them in social life, spiritual adaptation, and include them in social life. It is equally important to broaden social awarenesses about the freedoms and rights of children with disabilities, actions for changes in financing the specific needs of disabled children, adapting infrastructure to their needs, but also managing their free time in the best possible way for them according to their capabilities. Thank you for your kind attention. Thank you very much.
Thank you very much. Yes, it's very sensitive, I think, and sometimes neglected topic. Yes, like family with disabled child. So now, because we still don't have Dr. Zając, so I'll try to launch my presentation. One moment. Okay, can you see?
Yes, everything is okay.
Okay, so my presentation is entitled EU and Government Program Strategies in both. Sorry, no, in both, because in both it's the title of our seminar. Of course, in Poland as well as case law regarding new technologies in the implementation of the rights of children with disabilities. And in the first slide, you have some numbers. According to Eurostat, 4.4% children below 16 years old have disability in EU, and in Poland we have about 300,000 children. So it's 4.3% children with disabilities below 16 years old, and 19,000 age 16-24. This age division results from our disability assessment system linked to the legal age of economic activity. And this disability measured within this age limit similarly in Europe. So therefore we have, of course, difficulty in specifying the number of children under exactly the age of 18 in accordance with the Convention on the Rights of the Child. But the numbers mean that around 1 in 20 children have a disability. It's not insignificant number, I think. Fortunately, most have, of course, moderate and mild disabilities, only 1 in 100 severe. However, this 4.3% of children in Poland struggle with some barriers, often with prejudice or even discrimination. And of course, a child with disability, like any child, has rights under the CRC, and as a person with disability, also under the CRPD. Despite this positively assessed international instruments, it's difficult to define a closed catalogue of its rights. So its rights of child with disability, regulate at least to Human Rights Convention, and both focus either on the child in general or on the person with disability. And only a certain part of their provisions refers to the child with disability. EU strategic documents confirm that specific action should be targeted at children with disabilities as a particularly vulnerable group and at risk of violation of their rights. But things don't go as they should. We don't have many programs dedicated exactly to children with disabilities. Can you see next slide?
Yes.
Okay.
Yes.
Okay, because I can see you when I open my presentation. And now a few sentences about what happened before accessibility as an institution of international law. Of course, the European Commission has been supporting the development of disability policy since the 80s through action programs like Helios 1, Helios 2, and others. But however, it must be said that initially the EU used, as all international institutions, other legal instruments. There were principles of equal treatment, formal and material, substantive equality, equal opportunities. And the EU used not only bulk, as we call them, prohibitions of discrimination, but also positive action. Though integration was the leitmotif and there was no mention of accessibility, sometimes they were very ambitious. I pointed out an example from 90s. As you can see, the resolution concerning integration of children and young people with disabilities into ordinary system of education. But although EU programming documents are more important to us, due to the fact that they serve the implementation of the EU policy in our countries and the redistribution of financial resources. The Council of Ministers, I mean, the Council of Europe, systematically presented resolutions and recommendations on disability, and they concerned also education, social inclusion of children, even the institutionalization of children with disabilities in institutions. And both our countries are the members of Council of Europe. Hungary joined the Council of Europe even earlier than Poland, I think 1 year earlier. So maybe developing our analysis in writing, of course, we may mention the documents of the Council of Europe also. Back to the EU, besides integration with regard to education, the EU program strategies refer still to inclusive education. They also willingly invoke several international instruments like Salamanca Declaration or Standard Principles on the Equalization of Opportunities for Persons with Disabilities, European Social Charter, revised version from 90s, or the Council of Europe Action Plan for People with Disabilities. The inclusive education is also found in the Convention on the Rights of the Person with Disabilities and in the General Comment of the CRPD to Article 24. But of course, inclusive education has changed, and in the Convention, it was armed, if I can say that, with the right of access described in Article 24. At the time of accession by EU to the Convention, the Commission referred to a catalogue of legal acts on accessibility in the Annex 2 to the accession decision, and the Commission listed several early acts related to some extent to the principle of accessibility. Since 2000, accessibility has appeared regularly in EU documents, and understandable that the strategy 2010-2020 was based on Convention. The strategy listed accessibility as the first of its 8 action areas and contained ambitious goals, which were not always supported by ambitious actions. These actions also benefit children in various areas of their lives. Here we have examples in the area of accessibility, like the most important, I think, preparation of the European Accessibility Act, implementation of the other directives related to the new technology, further solutions for accessible transport, infrastructure or means of transport, full availability of public sector websites, supporting research into assistive technologies, using public procurement to improve accessibility, or generally revision of EU legal instruments in relation to the UN Convention. But as I said, ambitious plans do not always lead to ambitious results. And example of the Accessibility Act, it was supposed to be a universal act concerning the accessibility of many various goods and services. And finally, it contains only a narrow catalogue of them. Okay. We can. The current strategy, 2021-2030, is another document of this rank, of course, and accessibility has been named in this document a driver of rights, autonomy, and equality. What is important to us, core support services must include and be accessible to children with disabilities and older people. So children and seniors are indicated as 2 groups requiring special attention in the programming of actions and measures by states. Within the framework of accessibility, the flagship initiatives which may affect children, they are of course not always specific. They concern generally promotion, information, and coordination of activities. For example, are being implemented now or planned a framework for social services of excellence for persons with disabilities, guidance recommending improvements on independent living and inclusion the community. Accessibility EU, it's a knowledge base providing information and good practices on accessibility, or disability card. It's a European document that will make it easier to get the proper support when they travel or move to another country. And platform, disability platform, which brings together national authorities, organizations of persons with disabilities, and the Commission. It enhances cooperation and exchange on implementing the convention. EU strategy on the rights of the child. It's another document. It's not the first programming document about children. Strategy builds on previous legal as Commission communications on the right of the child, like towards an EU strategy on the rights of the child, or EU agenda for the rights of the child. And the strategy, of course, emphasizes that children with disabilities are more vulnerable to the violation of their rights. They require and deserve special protection. Children's rights are, of course, human rights, so every child should enjoy the same rights and be able to live free of discrimination, of any kind of abuse. And strategy notes that many children still face regular violation of their rights. They suffer from socioeconomic exclusion and discrimination, in particular on the grounds of their sex, racial or ethnic origin, religion, beliefs, disability, of course, either themselves or their parents. The actions indicated in the strategy relating to children with disabilities are as follows: combating poverty, building inclusive, high-quality education, ensuring the rights to health care for all children, child-friendly justice, the use of digital tools in learning, communication, and online participation in activities, or, for example, encourage information and communications technology companies to ensure that children's rights, including privacy, protection of personal data, and access to age-appropriate content, are integrated into digital products and services by design. And the Commission will pay special attention to children with special needs. I think it's visible that embedding a child perspective in EU actions is becoming more resonant. For example, separately, a new European strategy for a better internet for children has been prepared 2022. And this is the second strategy on this issue. And its aim is to ensure support for all children, of course. The digital environment must be diverse, inclusive, and free of stereotypes, as it said. Okay. Accessibility activities are financed or co-financed by EU, and operational program European Fund for Sustainable Development is continuation of program Knowledge, Education and Development. People with disabilities and their families are recipients of the program. Priority third concerns accessibility and services for people with disabilities. Solutions for support of adults, I think, dominate in this program. Maybe I won't repeat them. I just add that the program provides funds for the implementation of objectives and measures in priority 3. And now we can move to the Polish program. The Accessibility Plus program is the first and comprehensive approach to accessibility in Poland. And its purpose is to ensure free access to goods, services, and opportunities for people with special needs to participate in social and public life. Its broader scope than just person with disabilities. I pointed this out in a previous seminar, but this act imposes obligations almost only on the public entities, what was criticized. But now we are talking about program, and the program fulfilled its commitment because the law was passed. Yes, I mean the act. The act. The program focuses on adapting public space, architecture, transport, and products to the requirements or needs of all citizens. The sources of financing are European funds and public national funds like state budget funds of local government units. PEFRON, it's our state fund of rehabilitation for persons with disabilities. In Polish, we call this fund abbreviate PEFRON. Focusing on the program, what will children benefit from in the new financial perspective? The program provides various nationwide, local government and NGO projects and programs like projects developing models and standards for the provisions of public services. Now, as I remember, 9 projects. Within the program Accessibility Public Space, local governments, even religious or non-governmental organizations, healthcare entities may receive funding to improve the accessibility of public space and their services. Support is provided in the models like elimination of architecture or information and communication barriers, creating accessible spaces for children like playgrounds by local governments units, example by kindergartens or schools, elimination of technical information and communication barriers and equipment with assistive technologies. Another programs, local government barrier-free and active local government, contain funds for purchase, for example, an electronic wheelchair, care accessories, as well as electronic equipment or software. And they also pay for accessibility audits. We have also very specific programs like elevator program or a guide dog program. They are programs, of course, for the implementation of many necessary investment in residential buildings and for training guide dogs. Many projects are addressed also to the administration and entrepreneurs. Their effect will indirectly translate into improvement accessibility. In Poland, we have adopted a strategy for persons with disabilities, but I regret we contested the strategy for children. However, our national strategy for persons with disabilities, it's quite pretty good document. It was properly consulted with the community of people with disabilities, of course. As you mentioned about Hungary, this problem with execution of provisions in our strategy. What our strategy highlights regarding to accessibility, firstly, when we think about children, education, the possibility of implementing an individualized process and forms of teaching, rehabilitation, the choice of the type of school may be an expression of respect the maiden identity. We should respect the choice, even if it's the choice of a special school. It's pretty important, for example, for deaf children. Bilingual education is not guaranteed in Poland still. Law does not require, for example, the knowledge of sign language from teachers working with deaf children. Next step in the strategy is improvement the social and health protection. Attention is paid to the lack of full access to independent life in a family environment, institutionalization, also the cases of violence in institutions. In the last year, we had several cases revealed. Some of them are long-term abuse of children in institutions and also in psychiatric hospitals. Fortunately, we are closing orphanages and developing foster families. Nevertheless, the problem of taking care of deeply disabled children without a family remains. Can't miss services for the families. They lack causes overwork with care, lower income due to limited earning opportunities, even poverty of these families. From the next year, only parents of children, not of adults, dependent person, will be able to take social benefit even if they work. Now, if they work, they don't receive any support, but because of the lack of a support system, sometimes we think that it's only illusory opportunity because they can't work if then they don't have, for example, services for children in time when they work. According to international standards, we have institution for the protection of children's rights, the Ombudsman for Children, and this office should provide special care and assistance of disabled children. Unfortunately, in many cases, our current Ombudsman doesn't respond to repeated incidents of violence, either institutional or even domestic. The Polish strategy contains specific goals to be implemented. I've listed them below. What for children is important? Of course, any activities which improve accessibility in public spaces, implementation of universal design and uniform accessibility standards for public space facilities, kindergarten, schools, and educational facilities, increasing the accessibility of public transport, development of various methods of communication, conducting the institutionalization process, and introduction of systematic personal assistance. This is also related to that the children have rights to life in the community, in family houses, and to social life. So they need to establish relationship with other peers without the constant presence of parent for proper development and for social contacts, of course. Next, implementation of bilingual education for deaf people. It's pointed in our strategy. Alternative and assistive means of communication, preparing staff for the implementation of inclusive education, providing specialist medical care and preventive care to children with disabilities, improving the availability and equality of health services and access to comprehensive rehabilitation services and medical and devices of the highest quality. Very important, of course, for us in Poland, it's reform of the disability assessment system, because proper findings in the system are necessary to adequate support. We don't have spectacular judgments regarding children before, for example, the Supreme Court or the Constitutional Tribunal. We had such about adults and, for example, eugenic abortion, some regarding, for example, placement in the facility, also before the European Court of Human Rights in Strasbourg. But when we think about children, we had many cases in front of Supreme Administrative Court, our Polish Administrative Court, about transportation of children to school. The regulations guaranteed this, but were vague. Now they are very detailed. About subsidies for children with various types of disabilities at school, about access to kindergartens and schools. Still, we have regulations. They give certain preferences when they are more candidates to, especially to kindergarten or to secondary school. And I think last slide, instead of typical summary, a few words from our accessibility report. Currently, the most important and priority media does not contain information about the public policies in the field of accessibility on a macroeconomic scale, actions related to economic challenges or the state of health protection after the coronavirus epidemic are of key importance. The rising level of inflation determined the need for monetary policy intervention, and what is pointed, the enthusiasm of the community of people with disabilities in the field of cooperation with public administration for accessibility has won, and there is no effective pressure from NGOs on decision makers to make the improvement of accessibility. There is a focus on problems which often already have solutions in the law. And the last thing, the lack of dedicated budget for the program is increasingly noticeable. The program now only coordinates various means, doesn't have its own budget. And it's the end, I think. Thank you very much. Thank you for your attention. I was the last speaker, so if you have any questions or comments, please feel free to ask. Yes.
If I can, I have a remark. I wonder if we shouldn't standardize the terms we will use for the needs of our future publications, especially of a book, because we use different terms, a child with a disability, a child with special needs, or an illness child. In addition, we know the concept of being an invalid. There are, of course, not the same concepts. Of course, the concept of a sick child is the broadest, but we are, as I suppose, should be supposed to focus on the problems of a child with disabilities or a disabled child. This is just an observation to think about.
You mean we should look for some one term, yes, or
yes, because our main topic connected with a child with disabilities, but we use different concepts, different terms for this issue. I think that it's not a good way to describe the issue.
the title of our program, yes, it's about children with disabilities. So I think it's the main term which we probably
exactly.
should use in our articles. But sometimes even in acts we have other terms like persons or children with special needs. Yes, so I think we can use other terms also.
Yes,
especially
but
when we will
only,
comment some acts.
Yes, but only in the way when we stress that we use such a term for our papers, for our lectures, because it's not the same.
But what do you think, other colleagues?
Yes. Yes, a child with a special needs, I think, is the wider than a child with disabilities. So we should be strict when we try to explain some problems which is connected
in Hungary,
with
but in Poland,
disabled child.
And if we talk about, yes, sorry.
Okay, please, Marta.
If we talk about special needs in education, there are also some.
We use this term in Poland, yes.
Yes,
children with special needs.
Some aspects which can be connected to behavioral needs, so that the child has some, but also disabilities as well. So it can be interpreted broader, but I think if we start from the concept defining the CRPD, but I don't know. I think it's almost the same. I don't know, Nora,
Maybe
what do you
it's-
think?
Maybe the good solution is, of course, when we will use other terms, give some definition. Yes.
Yeah, of course.
Do we have a sort of language lecturing in the book? So will we have somebody who will read through and correct through the book?
We can ask the institute.
Because then in that case, it solves all our problems, I think.
Yes, correction. Mhm.
Sorry about that.
I think when we will use some legal terms, it's rather our task to give some definition.
There is only a linguistic proofreading now.
Yes, yes.
Whether it is, yeah.
That's what I'm talking about.
Mm.
If we have a proofreading, then
Yes.
it can help a lot. But made by someone else. And I don't know whether you have counted on it or not in the budget, because it costs a lot.
That's true.
I think there is a linguistic proofreader, but maybe Wojtek, you know more about it, because I don't know what is happening with our articles from last year.
Yes, yes. It didn't publish. It's sure.
I don't know. I try to get some information from the organizers, from Marcin or Paweł, because I don't know what was happened with our papers.
Okay. Thank you so much.
I will ask and I give the answer.
Okay.
Thank you. It's good.
Thank you.
Do we have other matters? No. Okay, so I would like to thank you again for the excellent lecture. So we can close our seminar and see you next month on August 10th, yes?
10.
Okay.
10. Okay.
Perfect.
Have a nice
Thank you.
holiday. Have a nice summer time.
Thank you very
Yes.
much. See you
Same
next
for you.
time.
See you
Bye-bye.
next time. Bye.
Bye-bye.